Imagine you are going on a road. You are following all the rules and didn't do anything wrong. But a bad policeman stopped you for no reason and arrested you. When you asked the reason for your arrest, the policeman didn't answer you and even took you to the station and locked you up. Taking advantage of your innocence, the bad policeman even tried to frame false cases against you. What are you going to do? What are your options to face this kind of a situation? Here's where our fundamental rights and writs play an important role in our life. Our constitution gave us 6 fundamental rights. These are mentioned in articles from 12 to 35, which are present in part 3 of our constitution. Constitution has given us these rights on paper, but until and unless these rights are protected, there is no value for these rights, right? Just like when you plant a sapling, there should be water and protection available. If not, its life has no meaning because it may be eaten or it may even die sooner or later. The same way, to ensure the protection of our fundamental rights, we have some constitutional remedies under Article 32, which itself is a fundamental right. This is why Dr. B.R. Ambedkar called Article 32 not only the most important article, but also the very heart and soul of our constitution. It gives us the right to move to Supreme Court and file a writ petition in case of violation of our any fundamental rights. Not only this, Article 32 also gives the Supreme Court the power to issue writs for enforcement of any fundamental rights. But what is a writ in first place? A writ is nothing but a written order issued by a court. The writs are of 5 types: Heavyest Corpus, Mandamus, Prohibition, Certiorari, and Cowarranto. In the movie Jai Bhim, a pregnant woman from a primitive tribal community searches desperately for her husband who is missing from a police custody. Hero Surya, a high court advocate, uses the writ Habeas Corpus to find her husband and seek justice for them.
कोर्ट में जो petition फाइल करेंगे वो है Habeas Corpus. कोर्ट में पेश होने की अर्जी.
Habeas corpus is a Latin word which means to have the body. If a person is illegally detained, he can file habeas corpus in Supreme Court under Article 32. If he is not in a position to file the writ himself, this writ can also filed by his family, relatives, or even his friends on his behalf. Once the writ petition is filed, in response to your writ petition, the Supreme Court issues the writ and orders the responsible authorities to produce the person before the court. The court would set the detained person free if the detention is found to be illegal. This writ of habeas corpus can be issued against both public and private individuals, which means if your boss locks you up in his office for some reason, your family or friends can file habeas corpus in Supreme Court. Then the police has to find you and produce you before the court. And please remember, habeas corpus cannot be issued in these cases. Mandamus. This literally means we command. The writ of mandamus can be issued if a public official is not doing his duty and it's leading to violation of your fundamental right. Let's suppose you decided to start your own business. Article 19 gives us a fundamental right to practice any profession of our choice. But businesses need licensing from respective authorities. If the licensing authority is delaying or declining your request, this violates your fundamental right under Article 19. In this case, you can file a writ petition in Supreme Court. The Honorable Supreme Court issues the writ of mandamus to the responsible authorities to perform his official duties. Mandamus can be issued against any public body, lower court, tribunal, or even against a government. It cannot be issued against private individuals, which means if Amazon is delaying your order, you cannot file mandamus against it. Apart from this, to enforce a departmental instruction or to enforce a contract, you cannot file a mandamus. It is to be noted that writ of mandamus cannot be issued against President of India, state governors, and Chief Justice of any High Court. Prohibition. This literally means to forbid. This writ is issued by a higher court to a lower court or to a tribunal to stop them from doing something what they are about to do. For example, let's suppose you are traveling from your home state to another state. In the border, unfortunately, you met with an accident. A case is filed against you. But while it is in the process under the court of your state, your opponent is trying to file a double case against you in his state too. This violates your fundamental right under Article 20, no double jeopardy, which means a person cannot be punished more than once for same offense. So to stop the other court from punishing you twice, you can file a writ in the higher court and the court will issue writ prohibition to the corresponding court and stop it from proceeding further. This writ of prohibition can be issued only against judicial and quasi-judicial authorities. Certiorari, which means to be certified. This writ is similar to the previous writ. As I said before, in case of prohibition, the person can move to superior court to prohibit the lower court to proceed further, which is like a preventive measure, right? But what if the lower court already admitted your case and given you double punishment even before you move to higher court? Too late, right? But there is a cure. Here's where certiorari comes to action. The writ certiorari is issued by a higher court to a lower court or a tribunal either to transfer the pending case or to squash its order, which makes the writ certiorari not only preventive but also curative. There is one more important difference between prohibition and certiorari. Prohibition can be issued only against judicial and quasi-judicial authorities, while the writ certiorari can be applied to both judicial and quasi-judicial authorities, and it even exceeds to administrative authorities. It's important to remember both prohibition and certiorari are not available against legislative bodies and private individuals. Now comes the last writ, Cowarranto. Cowarranto literally means by what authority. This writ is to prevent anyone from occupying a public office illegally. For example, you found a post of public office was filled without advertising any application or conducting a test. In this case, you can file a writ petition in Supreme Court as it is violating your fundamental right under Article 16, which gives equality of opportunity in public employment. When you file this writ petition in court, the court will pass the writ Cowarranto to the concerned public office asking by what authority that post was filled. This writ cannot be issued in the case of ministerial office or private office. Unlike the other 4 writs, this writ can be filed by any interested person. That's all about the writs. See you in the next one. Till then, peace.